Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, and holding up half the sky. Raise your hand if you're ready and willing. If you know it's time. Time for a girl on time. Time for a girl on time. Time for a
Things are a little fuzzy during the daytime. Hi guys. Sorry, I'm all confused. It's because my green screen reacts differently in the daylight than the night light. I'm a lady of the night. That's true. We know that to be true, and so this is bothering me, but there's nothing I can do about it because I didn't look at it until just now. I hope everybody's doing well today. I hope you're all doing better than me. I have not yet had my first sip of coffee. I'm late because I had to go get coffee. We talked about it yesterday. I was all out. Should have gone yesterday, but I didn't. Hi, John. How was your show last night? But I have coffee in my ragamuffin mug now. This mug is ragamuffin looking. But anyways, it's good. It's good. I hope everybody's doing well today. Like I said, I hope you're all doing better than I am. Thank you for the med check, Vicky. That's right, folks. It's a med check. That means take your meds if you've got them. Otherwise, come down to the chat and let us know what that's like. I gotta take mine. Whatever I can scramble together here. I want to pre-apologize for the audio in this courtroom. You know, if international tensions weren't so high, I might make a visit down to Huron County to fix it. That's a joke. I would not. But, I mean, it's the best we can do. This court had what was rocking all day in terms of, like, case after case after case that was crazy. But originally I was like, oh, maybe I'll put in the closed captioning ahead of time. But I didn't get around to doing that. So, shocker. Here we are. We'll struggle together. We'll struggle through together. Shall we? I think we shall. Tell me what you had for breakfast today. If you didn't like what you had for breakfast, tell me what you wish you had for breakfast. I haven't had breakfast yet, except for this joint and this coffee. Actually, not my least favorite of breakfasts, but pretty common breakfast, in fact. I don't usually eat breakfast very much either, unless I'm on vacation and somebody else is cooking. I already cooked breakfast this morning, but not for me. Not for me. Hi, Nabel. Steak sandwich sounds good. Oh, Paisley, get the chat off your face.
All right,
Judge. See, it's so bad, but we're going to get through it. I'm going to mute myself. We're going to listen carefully. It's going to be okay. It's going to be okay. It's going to be okay. Can you guys say that to me too? It's going to be okay. I did, man. It's going to be okay.
6, 7, 8:40 p.m. There are two matters before the court. There's a motion regarding parenting time, as well as a show cause regarding alleged failure to appear at a hearing. We'll begin with that. A show cause was entered on March 12, 2025. There was a hearing scheduled previously. I believe that would have been
I actually really like that spelling of Vicky. Vikiki. I like it. I like it a lot. How you doing, Tin Man? I'm drinking my first coffee.
March 7th.
Sorry?
It would have been, our court hearing was March 7th.
March 7th, okay. I'm just trying to find that. I appreciate that. Trying to find the notice here.
Drama-free day for Billy. That's what we all dream of. Actually, I have to work a night shift tonight at my other job. And then I have some preparing to do for our show tomorrow. We have a fun members only tomorrow. I saw Lindsay earlier said that she got a membership. That's awesome. Tomorrow, members only is going to be not one you want to miss. If you like me. If you don't like me, probably miss it. Just saying.
Officials, do you see that as well?
Mr. Palmer, motion was filed and signed by the town clerk's office as of January 31st, 2025.
Got it. I just saw it. Yes, thank you. This is an alleged violation of judgment of divorce scheduled for March 7th. And there was a certificate of mailing on January 31st. These are the days. Correct?
The January 31st filing was set for hearing on March 7th. It was more than 30 days notice.
Okay. And both parties, please raise your right hand.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Thank you. Ms. Houston, you did not attend the hearing.
I did not.
Why not?
I never received a notice of hearing.
I'm not going to go through the total address, but it's still 987, correct?
Yes, but that's not the address that it was sent to either. So,
Well, the notice of hearing indicates that.
I reached out to the court. So Monday, March 10th, I received a notice to appear via my mom's address, to my old name and my parents' address, that I didn't show up to this March 7th hearing.
Okay,
I
so-
emailed.
What is that? What is that warning siren, y'all? I was freaked out listening to this. Nobody is reacting. Nobody. But it does remind me, I want you to look at the woman in the very back of the courtroom over there. I'm gonna have to fix this filter again. Control Z. Because she is, here, you can see my mouse, right? This lady back here gets very animated during this hearing. So keep an eye on that. She, I believe, is the new baby mama or new lady. She's the new lady in town. I'm trying to fix this thing, you guys. Trying to fix it. Anyways, so I guess a test. Nobody seems to be reacting to the test. I was like aghast. Anyways, let's continue. Prep your ears. I thought it might summon Ryan Hall, y'all.
The court and Mrs. Schultz and Maria Hobecki that I never received anything, a notice of a 3-7 hearing via mail or email. And that had I known about it, I would have absolutely been here. And then I went back Tuesday, the next day, Alicia from the court emailed me that Mr. Pomeranke filed it on January 31st. And she mailed it to 971 Lakeview Drive.
She mailed it to 971?
That's what she told me. Alicia Thomas, I believe. I can look up the email. And at which point I asked her, I said, okay, well, that's not my legal name or my legal address, but that's fine. I don't know why I didn't receive it, but I also asked why it was never emailed, as everything else has previously been emailed also. But regardless, I never received this, this letter, and it was mailed to 971. My mom is here to also say that it never came to her house. If it would have.
Do you have the documentation?
What documentation?
The documentation of the notice of hearing sent to 971.
Like that the court told me that?
No, do you have the documentation You claim that it was mailed to your parents' address.
Right.
Do you have the documentation with you today?
It never came to my parents' address. That's what I'm saying. It was, they said it was mailed to my parents' address, but it never came to there either. I did not know about this. I never received this document.
Because the notice of hearing has 987. I don't know why the county clerk would send it to another address.
And I did address that with the county clerk, and that was the last conversation that I had with her. I did say it even, because she finally emailed it to me, what was sent. I didn't know anything.
Hi, Miss Carrie. This is not a drill. This is not a drill. Miss Carrie's here. No, I'm just joking. I hope you're doing well. Creed taking the day off of gambling. I hope you're doing well. This lady, we just had a tornado siren go off in this court. Nobody reacted. Nobody reacted. Except me. I reacted. Again, worried that it will summon Ryan Hall, y'all, when we sound those tornado sirens. Also, Bill raises a really good point. What happens if there's a real tornado during the testing time? That creates a problem, doesn't it? Has anybody thought of that? Did they pick the least, problematic time for it? Like real, midday on a Friday? Interesting. If you were nefarious and you wanted to create havoc in a city, I should not say this, but in reality, if you were because a lot of places do alarm testing the same day of the month, right? If you were nefarious and you wanted to create some havoc, you could go and cause some problems during that alarm testing time and cause some problems. Anyways, also, but cellulite yoga pants, there you go. Plus your phone won't go off. Ooh, Miss Carrie. Oh, damn. Oh my God. You guys, Tin Man, sound the alarm. Creed has the alarm. I wish I could sound an alarm. Tin Man is out of Diet Pepsi. Woo! What's the alarm? That's my best alarm that I have. Okay. And Miss Carrie, I'm all for it. I love to see the gambling. Okay. Rose, hello. We are here. The alarm has just gone off. And my alarm has gone off. Okay. I gotta take my medicine and we gotta get going.
About what this even hearing was about. And at that time, I said, Mr. Pomeranke, even, his address is on there. My address is listed as 987, And then furthermore, she said something about me updating the address because I asked them how they even got that as my address, the county clerk's office. I've never legally resided at 971 in many, many years.
Right,
So-
well, we need to have the deputy clerk here.
He's gonna do something here that I've never seen done. And Miss Carrie, I hear ya. That's actually why we're here, to watch other people's problems and avoid our own. Miss MB, driving bus? Driving but listening is what she's gonna type. Please be careful. You don't even have to type it.
We're bringing it to stop.
You don't even have to type it. We know. You'd be safe. Oh, Tin Man. Found more Diet Pepsi. We love to hear that, sir. Sometime. Oh, yeah. Do Miss Carrie.
That today's hearing,
Sure.
certificate of mailing indicates 971 Lakeview.
Nobody go to this lady's house, by the way. They're
Again,
all
Your Honor,
talking about the
don't
address. I
understand
can't
how the
believe
county
it.
clerk has that as my address. And she said her response was something about that I needed to change it if I changed it with the front, but I've lived at 987, my legal address at 987 for 10 years now. I mean, I don't know.
Ms. Thomas, would you please step up to the witness stand?
I'll prepare, Miss Carrie. I work a night shift tonight, a 4-hour shift. Who's this? This is the clerk. They're bringing in the clerk. And she got a big booty. I like it, girl. But I'm prepared, Miss
Do
Carrie.
you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Please be seated. Would you please state your name for the record?
Alicia Thomas.
And Ms. Thomas, are you employed?
Yes.
In what capacity?
Currently, I'm the deputy election clerk. Previously, I was a family court clerk.
Okay. Were you in that position, the previous position, back on January 31st of this year?
Yes.
Okay. I'm handing you a notice of hearing and motion. This is important. This was filed by Mr. Pomeroy.
Yes.
Take a look at that. And do you see the address in the top right for the, it's really supposed to be the plaintiff, but he lists her as the defendant.
The 987?
Yes.
Yes.
Okay. Now, at the very bottom, there's a certificate of mailing.
Yes.
And did you mail out the notice of hearing to Ms. Pomeroy?
Correct.
I'm sorry, to Ms. Howison?
Yep.
And what address did you use?
I mailed it to the 987 South Lake Shore, and then I also mailed it to the 971, I believe. Whatever address that we still currently had on the system.
So you sent 2 notices?
Yes. If the addresses aren't the same than what the people write on the form, and I should have wrote that, I send it to both just to make sure that they get the correct information.
Okay.
And I let her know in the email that I did email it, or that I did mail it to both.
Okay. Oh, you let, I'm sorry, you said something about an email?
Yep, I emailed, Ms. Howison last week, letting her know that I did mail it out to both addresses.
Any other questions, Ms. Howison?
I would like to read the email.
I can go over it now.
That's fine.
Well, it's,
So, guys, you have to understand something here. This is unusual, very unusual. The clerk doesn't usually get called in. Oh, God, Miss Carrie, I'm so terribly sorry. But the clerk doesn't usually get called in to these hearings. This is very unusual. I feel like the judge is not super lenient towards mom. Michael, the sex offender. Oh, Rose, you're so funny. That is from another case in this courtroom. This courtroom has notoriously bad audio, but then it picks up on so random stuff. Hi, Lindsay. It's such random stuff. Such random stuff. Anyways, okay. We are listening to this case. There's 3 motions that they need to have heard. Damn it, Adam. Damn it. That's okay. You're not that late. You'll find that 18 minutes for Paisley is pretty much the beginning of the show. My medicine hasn't kicked in yet, so I'm still forgetful, but we're watching this. The clerk has been called to say, I actually sent the notice, and the judge is going to tell this lady, you say you didn't get it, but did she get it? Oh my God, Bill, that's so funny. At your granddaughter's birthday party, you painted rocks on the bottom of your rock. I painted, stop looking at my bottom. I like that. That's hilarious. Oh, I love that so much.
but that was last week, correct?
Yes.
Okay, well after the motion is filed. Do you have any questions regarding the questions the court posed? Ms. Howison?
Is she printing the email or can I read this? I have the email from her. Good morning. A motion was put through by Mr. Pomeranke on January 31st and I mailed it out the same day. It was mailed to 971 Lakeview Drive, Harbor Beach. This motion was not put on by his attorney. I can email over a copy for you. We do charge $1 a page. That's
Okay.
the email I received from Ms. Thomas.
Yep, that was the one that was like 2 weeks ago, but the latest email that I sent, which was last Thursday or Friday, it said that I had mailed it to both. The address that we had on file and the address on the mail, on the paperwork.
Okay, but I don't understand why, what why you didn't say that to begin with. I mean, I was asking about it.
I probably was gonna add it, I was probably busy at the time.
Okay. So regardless, I mean, I never received this letter. I mean,
Well, do you have a question? I'm sorry. Because I know you stated that. Do you have a question for Ms. Thomas?
no, I don't have any questions for Ms. Thomas.
Okay, I do. No doubt in your mind, you mailed it to both as of the certificate of mailing January 31st.
Correct.
Both addresses.
Correct.
You may set that. Any other comment, Ms. House?
I mean, about all of it.
Before you comment, Miss House, first of all, good job, county clerk. Apparently, is it Jeans Day Friday, you think, or Jeans Day all the time? That's my question. My butt is not that thick. Just saying. I wish. Anyways, also, what is this core water? I looked it up. It doesn't appear on Amazon.ca. Oh, Carla, you might have to go to YouTube, but you have until tomorrow. Tomorrow is members only. But you might have to go through the YouTube website or don't use Safari for joining on an iPhone. That's all I know. YouTube Daddy and Apple Daddy fight. They fight. And they don't want to share. But that's what is it? Bougie water? Is there a taste? Does it have protein? What is it? Why is it so big? I thought she had literally taken a laundry scent booster package and filled it with water, and I was disgusted. The lid is a laundry scent booster pack. You know what I'm talking about? All of those, what are they called? You know what they are. Scent boosters. I think that's what they're called. And they come in like black on the bottom and then like pink on the top, or pink on the... How much does it cost? For water, that big of water. This lady... Oh, interesting. Oh, gosh. Sashina, that's not... an emergency. An 8-pack for $5.99. That's an emergency. That's expensive. Oh my gosh. I feel bad when I buy bottled water, even though I drink a lot more water if I buy bottled water. But I will only buy like the 32-pack for like $3 with the extra microplastics. Obviously. Tastes just like Smart Water. I do like Smart Water. Do you guys have bulk water? BLK water? Or black water? Where it's black?
In general?
About failing to appear.
Okay, I did not receive a notice of the court hearing on 3/7 to either address.
Okay. Well, we had an officer of the court testify to the contrary. She further testified under oath that she mailed to both addresses. As a result, notice was properly filed in this matter, and I find you in contempt for failing to appear.
Could it have been lost in the mail?
That's not in the court rule. Proper service is conducted as soon as it's placed in the mail. In
With
this
all due
situation.
respect, Your Honor, we have been doing this a very long time, and I'm very well aware.
With all due respect, always follows without respect. We'll let you finish that in a second. But let me just show you that bulk water that I was showing you here. BLK water. It is literally pitch black. That's not the container. The container is clear. The water is black from like charcoal or something like that. It's crazy. Crazy. I fell for it. I bought it. I was like, what does this taste like? Is it going to be gritty? Is it going to be gross? It just tastes like water. It was so expensive too. It was like $3 or $4 a bottle. I was like, felt so dumb. So dumb. No, I mean, everybody shits. Not like any more than normal.
under oath that she mailed to both addresses. As a result, notice was properly filed in this matter, and I find you in contempt for failing to appear.
Could it have been lost in the mail?
That's not in the court rule. Proper service is conducted as soon as it's placed in the mail. In
With
this
all due
situation.
respect, Your Honor, we have been doing this a very long time, and I'm very well aware of what can happen if I just don't choose not to show up for a hearing. I swear to God and everything, if I had notice of this hearing, I would have been here. Why would I want to cause more stress for myself or disrespect this court?
Oh, I'm not finding any disrespect of the court. It's a matter that a notice of hearing was filed. It was properly mailed according to the testimony of the clerk, as well as her previous oath that she administered. Father appeared. Obviously, you did not appear. You claim you did not receive it. I'm not saying whether you did or didn't, but service was proper under the court rule. That's what the court has to follow. Is there anything you'd like to say before the court imposes disposition?
No.
Thank you. The standard $100 fine will be imposed. That'll be due April 11, 2025.
May I ask something, Sharon?
What's your question, sir?
This is not the first time you missed a court order appearance.
Sir, you just won. Okay? He held her in contempt for not showing up. I sort of believe her. I don't think, like, she's prepared. Look at her. She has a notebook. Do you know how many people come to court that don't have notebooks? It's a lot. Most of the people, okay? So my whole point being, like, one of these things is not like the other, where she's organized to this point. She followed up on it. The clerk did say she sent it to the wrong address. And again, I just think the judge is like, I don't know. I don't think he's happy in this case. I don't think he's happy with it. But remember what I said, the lady in the jeans in the back, she gets very animated throughout this case. All right. And I guess $100 fine is one thing, but we're going to find out shortly, already doesn't have any money. So I always worry about courts. You know, I have real respect when a court says, I'm not assigning fines because I want all the money to go to child support, or I want all the money to go to the not retribution. What is the word? Recompensance would also work, but that's not the word that we need. Somebody will tell me what the word is.
She missed 4 depositions. Well, that you have ordered throughout her divorce trial. She missed 4 depositions and then
It's restitution,
Right,
yes.
but
Thank
this
you,
is
Ms.
one that
Carrie
she
and
missed.
Adam.
For you in this court proceeding, depositions are different.
okay. Well, then, okay. I didn't know. All
But
right. Thank you.
she's, and that's paid in front of the court office. Sure, and we placed it both under oath. What's your motion regarding hearing?
I was on my daughter's TikTok and just doing my parental checks, making sure she's not talking to nobody she's not talking to, supposed to be talking to. And they were in the car with alcohol. And our order of divorce states there's not supposed to be any alcohol 8 hours prior to having children.
Okay, so he's claiming that he's on his daughter's TikTok and he sees mom drinking alcohol in a car. Okay, play the TikTok. Play it up. Cue it up, folks. Cue it up. Also, I mean, positive vibes for checking your child's social media, although I'm actually not really a fan of checking their social media as opposed to creating an ongoing open dialogue with your child that allows you to converse about different things all throughout time, as opposed to like trying to catch them doing bad things. I don't know. You know what I'm saying? But that's just me. It's just me.
and I printed off a copy, a picture, I sent it to, this is, Ms. Schultz, and I also have a copy that I printed off last night at Walmart.
Okay, so you have a photograph with
Yeah,
you?
yes, the court's due is from Ms.
Well, I don't
Ms.
know,
Schultz,
whatever.
I'm sorry.
That's okay.
It was attached to the show.
It is attached, okay. Oh, that's right, it is. Okay. But it's not for the court to consider at this point. Have you seen the photograph, Ms.?
Actually,
Yes.
I have a question,
Any-
you guys. I don't use Facebook. You guys know that I really don't use Facebook, but my roommate uses Facebook all the time and is applying for jobs, and so I told him that he needs to lock down his Facebook so that jobs can't see it. So it doesn't seem that easy to do. I turned the privacy on to friends only. Is that enough to make his profile not like searchable when you search it? Or is there like another setting for all you Facebook users out there? I know some of you know this. I know you know.
Objection to the court reviewing it?
No.
Okay, sir, we'll take it. We'll have it marked as defendants 1. It's admitted.
There's 2 photos, one email black.
One's black and white, one's color. Any problem with both of those? I've not looked at it.
They look like different photos. Your Honor.
Well, which one do you have any objection? Which one do you have an objection to?
I'm just pointing out that they're different photos. You asked if I've seen them and if I would object to them. I've only seen one photo. I've not
Okay,
seen both photos.
I want you to see both. We'll hand them down for you to look at.
He had his damn phone number on there. Like searchable to everybody. I was like, oh my god.
No, I have no objection, Your Honor.
Okay, thank you. Appreciate that.
Yes.
We'll consider them 1A and 1B. Okay. It's admitted. Sir, do you have any idea when this photograph was taken?
It's a TikTok video, so it's a screenshot of the video that's on TikTok.
Okay. Does it indicate on the TikTok app when this was taken, if you know?
Can I go on and look quick?
But
I
if
don't.
that'll refresh your recollection.
Just give me 2 seconds.
Hi, Christy. Thank you guys. I just reminded him to.
221 it says on that.
February 21st, okay. And you're offering this, it's admitted that it's a violation of the court order, correct?
Yes.
Anything else?
Yes, I had also was going through my son's phone and I found pictures of more alcohol. It's just chilling, just sitting in the hallway.
Alcohol just chilling in the
I
hall.
think Wednesday or Thursday, Ms. Schultz, sorry. I emailed Ms. Schultz Wednesday or Thursday with it. I think Thursday, yesterday. And let her know. She told me to bring it to court today.
Do you have photos of those?
Yes, I have one photo.
Would you like to show that to Ms. House? Please show. Any objection to the court reviewing that photograph? Sir, would you like to present that to the court reporter? And that'll be marked as well as plaintiff's choice.
We'll give it to him.
He isn't dressed for court.
Sir, anything else you wish to present on this issue?
No, Your Honor.
Ms. House, your response, please.
My response is I don't know when or where this photo was taken, nor am I consuming any alcohol in the picture / video. I'm not even in the photo. Further, based on what he was just saying, there's really no way to know when a photo was taken, only when it's posted. But I didn't realize The date in question, he just reported that it was taken on February 21st, which was during his parenting time, actually. Again, I don't know,
This is contempt. He's
I
asking for
don't
her to be
know.
held in
I'm not
contempt.
consuming alcohol in the picture video. I did read through the motion as it was presented with the email exchange from Mr. Pomeranky and Ms. Schultz, stating that she had reviewed it and did not see an indicated of alleged order violation because the JOD provision is that under neither party consume alcohol during parenting time. Again, I'm not consuming any alcohol during parenting time. This is not proof of that. As far as the second picture that he just sent now, saying that it was from my son that took that photo. I don't know when or where this photo was, well, I know where it was taken, that one is in my hallway. I don't know when it was taken, Brendan comes and goes all the time, and, it could have been on my own personal time. However, that's still not my alcohol, but, and still not proof of me consuming alcohol. I guess that's really what I have to say about it.
All right, thank you. Any rebuttal arguments, sir?
No, just one thing, Your Honor, it was actually posted 17th. I'm sorry, which would have been her parenting time, and it's her vehicle. I don't own a vehicle.
Humble brag. I don't even own a car, Your Honor. So it couldn't have been with me. That's like a reverse humble brag. Especially in America. Like, in Canada, that's sort of okay. You can live in a city where you have public transit and not need to own a car, and you can get around appropriately. But in most of America, that's not the case. So it's like a reverse burn for himself. And then also, she's making a good point here. Are these videos of her consuming alcohol? Questions, questions, questions.
Okay,
Oh yeah. Here.
any other rebuttals?
No, just alcohol has been an issue with her. I'm going on 5 years this November, this August, and 1 year or 2 years, no smoking cigarettes, November.
What page is in the judgment?
I feel you, Miss Carey, but
I'm trying to find it.
insurance is so expensive around here. But actually, what I actually think, sorry, I'm going to join the car share co-op. We have a car share co-op here where you pay a small monthly fee and then you can rent the car. They have them all over town, and there's one like just down from us. And it's very cheap comparatively to owning a car or to renting a real car from a rental company. And they've been around in my city, Victoria, for like 25 years. People have been doing these car share co-ops. And I think I'm going to look into that, because then you can just get, when you need it, you just book it online and then you go pick it up and then you drop it off wherever you want, like whatever spot it is, and then you're good for it. You get insurances covered with it, and they have all different kinds of vehicles, so you can like they have pickup trucks, they have vans, they have electric vehicles, they have cars, and they have a lot of them. Even the city gives special parking for them all throughout the town to encourage people to not own cars but to be part of the car share co-ops. They've got specific parking. So I think that's probably my next agenda for that, because that way when I want to do a big grocery shop, I can just book the car for the afternoon and do the shop.
Our written opinion and judgment, of course, isn't numbered, Your Honor, but it would be page
Instacart, I imagine the cost of Instacarting something would be very similar to the cost of renting the car for the afternoon. I'm not joking, Miss Carrie. And I agree, I love Instacart too for people, but I hate paying fees like that. Even when I do my grocery pickup order, I do a pickup order, even though I don't have a car, because I'm like $18 or $20 for delivery is like a lot to me. That seems like a lot. But, and some people Instacart stuff all the time. Now, Ed's raising a good point. Wouldn't it be cheaper to just take a cab? This way you don't have the monthly fee. But the cab is not the same as being able to have a car and drive wherever you want. So let's say I want to spend the evening or the afternoon and I want to drive to the Walmart and I also want to go to another grocery store and I want to check out Costco, or I want to, it just really limits you to one point to the next point in a cab or an Uber. We got Uber now, amazing, but it's very expensive. So the whole point being that I think the monthly fee is very low. And then, you only pay for what you need. So, and I walk most places, but I will say that I would love to be able to just like spend the afternoon driving and just being able to be like, oh, they didn't have that here. I want to go to this store over here and not worry about, oh, fuck, I've already got a bunch of shit, That's the joy of having access to your own vehicle for a couple of hours. Your own vehicle.
Second paragraph above communication.
Well, I'm looking at the child support order. When was that judgment entered?
July 18th. And the provision at issue, Your Honor, is that neither party shall consume any controlled substance except as duly prescribed, nor shall either party consume alcohol 8 hours prior to or in during any such.
Zip car, I like that. Zippity doo dah day. Yeah, dude's just scrolling on his phone, right? We can see him, Adam. Crazy. This court all day had crazy cases, I told you guys. I got most of them.
Okay. All right, the court has received evidence in the court, in the record, specifically regarding alcohol reportedly possessed by the plaintiff in this matter. One of which appears to be in a motor vehicle because I see a seatbelt. And clearly, as I move my glasses, that's a White Claw emblem, which would indicate alcohol. The second photograph is a case of Miller Lite beer as well.
Poor taste.
Can't tell whether it was opened or not. It doesn't appear to be, but I'm not sure. The allegation
It wasn't,
from
Adam.
the
It's
father
Huron
is
County,
that mother
Michigan.
violated the terms and conditions of the judgment of divorce with possession of alcohol while the children are present. And the order, the judgment indicates that neither party shall consume any controlled substance except duly prescribed, nor shall either party consume alcohol 8 hours prior to and during any custodial time. There's been nothing presented on the record to indicate that consumption had been done. Clearly possession, but that's not prohibited by the judgment of divorce. As a result, the defendant has failed to sustain his burden in this case, and the show cause is respectfully dismissed and denied. That'll be all. Thank you, everyone.
Now we have one more.
Oh, I missed one?
Yeah, for
There's two more.
judgment of divorce issue.
Okay, let's.
Two
one
more. Oh, no,
second.
you weren't bothering me, by the way, Rose, at all. That's never a bother. Always send me them. And I was recording them and trying to download them. I have multiple methods. But did you see that? The judge thought he was done. He was like, okay, you're free to go. And they're like, no, bro, we got 2 more. So this guy has filed 4 motions against her. Contempt motions. And once again, this is Huron County, Michigan. Actually, one of the most self-sufficient pro se courts, I would say. Very open to people pro se filing motions. And they do. And they do. And they do.
There's also the issue of the school year parenting time.
Oh, yes, I forgot about
And
that.
then Mr. Pomeranke has a property motion.
Okay, I completely forgot about that. Let's talk about the custodial time. And I believe what Mr. Pomeranke was looking at was a modification of that to keep the days contiguous with the overnight, correct?
Yes, yes.
Okay, and what is it that you're proposing, sir?
Getting rid of the Wednesday overnight, adding it to my weekend time. So instead of going back Monday after school, they go back Tuesday after school. The least interruption for the kids. We're doing that now. It's enjoyable. It's not, they don't have to go back Monday, pack up, come back to my house on Wednesday. It's just smooth flow and it hasn't been an issue.
So you wanted to put it at the tail end?
Yes, but on tail end, I had conversations with Ms. Howson on APFOs, sent them to Mrs. Schultz. She agreed. Didn't matter if we put it in the beginning or end. I said, okay, I choose the ending. This way it just flows, no big deal. They just stayed in my house one more night. And she said, no, you're not gonna do that because that's not what I chose. And I got told, no, it's on APFOs, and ask Ms. Schultz. She told me no, and she told me yes, because that's not what she wanted.
Okay, this is your response.
I'm sorry, I was just reacting that I don't speak that way, but anyway. So I was a bit caught off guard by this. I didn't realize that we had any issue as we've been doing it. The kids have been going Thursday to Tuesday for 3.5 months now or whatever. Mr. Pomeranke and I began talking about this back in the beginning of the school year. We both absolutely agreed that the children do not like to come home Monday and go back on Wednesday. It's kind of an upset for them and they haven't enjoyed it. So immediately, I just said, we'll figure it out. And so he said, I would like to do it Thursday to Tuesday. And I said, well, I would like to do it Wednesday to Monday if possible. It doesn't really matter if they go a day earlier or stay a day later, in my opinion. So I just asked him if we could, and he said, no. He's the one who said, nope, Thursday, Tuesday only. So I said, can we try it both ways? I think they have posts, well, some of the have posts attached because the whole conversation isn't in there, but multiple times.
Statements between the parties, if you come up with an agreement on your own, unless it's court ordered, the court can't honor it. I mean, you can agree to whatever you want to agree to, but that if it doesn't follow the court order, then the court order still trumps. So I guess my simple question for you is, do you have any problem with doing it at the tail end rather than the front end?
No, I don't. And that's why I'm just explaining the whole thing because the other accusations in this motion was that I'm, causing problems or whatever. I mean, you could.
Well, I'm trying to cut through the chat.
Yep, go ahead.
So all I'm asking is, father wants to do it Thursday to Tuesday,
Correct.
right?
Yeah.
Do you have any problem with that?
No, but I would like it noted that I was trying to do
Oh,
a
no.
compromise.
Again, I'm cutting through that. Remember the whiteboard story?
Yep. I
Clean
would just
slate?
like it noted that I tried to compromise and he said no. So yes, I will give him his way. It's perfectly fine that we do
Well,
Thursday.
it's not a matter of giving, just a moment, guys. It's not a matter of giving him his way. It's what's in the best interest of the children. Because you told me as well that it appears that the children like this way, doing it that way rather than plucking them out one night during the week. Right?
Right.
Let's
They would
just go with that.
They would just as well.
Let's just go with that. Best interest. I agree with it.
And it would also be in the best interest of the children to do Wednesday to Monday. It's no different whether it's the beginning or the end of it. That's the point.
Right.
And
but-
I'm just making note because it's been a continuing thing that I was
Okay,
reasonably trying to
again, Ms.
compromise.
Housen, I'm going to interrupt. You stated that you felt you had no problem. I don't care about the communication between the two because I know how bad the communication has
I
been.
know, and that's. the
But,
point I'm making.
excuse me, please. You find acceptable the Thursday to Tuesday, right?
I do.
That's what everyone agrees to. Let's just go with that.
Okay.
Court finds it's in the best interest and we will modify the order to reflect that effective.
Just for clarification, If the court can confirm whose weekend is currently with the kids, so we can put a baseline order.
It's
based on date
or
order.
spring break, so she
Oh,
gets spring break this year.
Who had last week?
I did.
Okay, got that.
Yeah, it is my regular weekend, regardless of.
Okay, what about the property issue, sir?
She was held, or she was supposed to take care of the home window loan and did not.
That's right, that's the old motion.
Oh, it's been over a year and it hasn't been paid on in over 3. I was the last one to make a payment when I lived in the home. Before I got incarcerated. She did not make a payment since.
Before he got
Everything,
incarcerated.
Sent all the payments. Last payment was September 2nd, 21, which was, I was the month, 2 months before I went to jail. I paid it and it hasn't been paid since. She agreed to it in court, saying that she would take all debts held liable with the home, and she would happily take it, that's exactly what it said. And had not done anything to take it out of my name. I called foundation. I can't physically do it. They won't let me do it unless she acquires her own financial loan or financial term, whatever, to take the loan over, to pay the loan off. Now they won't accept that because it's past it. They closed it. It's not closed, but.
Remind me, was that in your name originally or was it both
Both.
names? What page, because I do recall that, but what page on the judgment of
It's,
divorce is that reflected?
I printed off a copy. It should, I think it should be with it of the orders. I have it here. The part of, I printed off the order that states that I'm supposed to be held indemnified and harmless from the home loan.
But we don't have the page number on that. That was my fault.
I don't have it on this either. There's a highlighted area. in
This
the
is
middle.
where the lady in the back's gonna get really animated, by the way.
Show you mine.
Good page from the end.
This is such a mess, by the way. Remember, these people fucked, right? These people fucked. Don't forget that. That's what brought us here. If y'all didn't have babies, we wouldn't be here.
Apologize for the delay. It's a lengthy file.
So much animosity. It's like, how did they ever manage to copulate?
Foundation Finance, right?
Yes, sir.
Got it. Okay. Ms. Howison, what's the status of that loan?
9/2/21 was Dave's one and only payment on this loan that he was previously ordered by this court to be responsible for in our original judgment of divorce on August 13th, 2021 until the second judgment of divorce entered on July 18th of 2023 for 2 years.
Well,
payments-
that order was
No
vacated.
payments were made by
Excuse me,
him.
miss, that was vacated. The note, the judgment
in the
of
back.
divorce indicates there's also another encumbrance on the home, specifically a window loan from Foundation Finance with an outstanding balance of $11,956. Plaintiff states that the parties are currently behind in payments based upon correspondence received in July 2022. Clearly, the debt owing on the marital home exceeds the value of the home. Based upon the evidence presented, it is hereby further ordered that plaintiff shall be and hereby is awarded the marital home, subject to the underlying mortgage and window loan, and shall hold harmless and indemnify the defendant from both mortgage and window loan. It's your loan.
Correct. Following our most recent judgment of divorce on July 18th, 2023, it was deemed my debt and I called them to handle it. There's no way to take his name off of the loan. They don't do in-house refinancing. This loan has gone to collections and was charged off, which I was trying to just make a point during the time that it was Mr. Pomerangy's responsibility. The only option to get his name off it is to pay it in full. There's no way to bring the loan current since he let it go to collections, and it stays that way until the payment is paid in full. So paying on it now brings the balance down, but it still shows a negative on both of our credit reports until paid off. So I am paying on the loan. I'm willing to continue paying on the loan moving forward. I do not have access to $12,000 right now to pay it off in full to be able to remove the same off. I don't know.
What have you been making on payments?
I just resumed making payments now.
When? Just now?
Yes.
Well, hold on,
I'm sorry.
I'm still asking questions here. So this order was entered on July 18, 2023,
Yes.
and you're telling the court that you've not made a payment until 2025?
No,
You were not saying that, or you are saying that?
I am saying that. that is
Why was there payments made after the order was, judgment was entered?
With all due respect, Your Honor, the lengthy divorce and all of the things that have gone about all of this have been a financial hardship on me.
Well, I couldn't imagine. I agree.
Yeah, so again, I reached out to them immediately and there's nothing that I could do in making those payments right away brings it current or fixes the problem that was already there. So I just put that on the back burner so I could handle other financial responsibilities at this time.
Such as what?
Such as what?
Yeah, what other obligations? were
Oh,
you-
paying off the legal fees and supporting my children.
Okay, well, there's nothing in the judgment regarding paying legal fees first. Right? I mean, it's court ordered in this thing, that you're supposed to pay this mortgage. this
Well, what
debt.
what his legal fees, Ms. Hovecki was threatening to take me back to court if I didn't get that paid to her. I mean, it's coming at me from every angle. But regardless, Your Honor, I apologize.
Well, it's not a matter of apology,
I will-
it's just a matter of simply following the court order.
And I will make the payments moving forward. That's all I can do.
What are you requesting, sir?
I would like it paid in full. It's ruining my credit. It's on my credit.
Sounds like it's ruining her credit.
It is.
It should have been
It's
paid.
the one who
She
let it go
said,
to
it says right
collections.
here, the plaintiff will be happy to take over the loan. She said she wanted it. If not, sell the home, add it, and then pay off the windows. Sell the house. I'm trying to move forward with my significant other and my family, and I need to buy a bigger home. And I can't do that because I can't get a loan because of my credit. And I got hardships too. I have a house note and legal fees. I'm not complaining. I'm not crying. Everyone has issues, but I'm trying to take care of my stuff legally. And this is the legal way to do it. I can't force her to pay $12,000, but I need my name off the loan in order to move forward with my life.
What is it going to take to get this out of collection?
There's no way to get it out of collections other than to pay in full. And they don't do in-house refinancing, so they told me I would have to get a personal loan or some other
I
way,
recently
which I've already
spoke-
taken out personal loans and credit cards.
It's gotta be paid.
Yep.
I recently spoke with Foundation 2 months ago, and there was no payment up to then.
Well, she admits, she just
It's
started paying.
not about the payments, that doesn't.
It comes down to the obligation.
Yep.
It's gotta be paid, that's part of the court order.
Also, Your Honor, the house is supposed to be on my
Excuse
name
me,
as
sir.
well, but I can file another motion, sorry. I'm not trying to cut you off, I was just.
So you did, but
If you want
I've
to,
been cutting everyone
since
else.
we're
because
here-
No one's listening to my question.
sorry, Your Honor.
Don't be sorry, you're fine.
For cut-
What are you going to do regarding payments? Is there some sort of settlement that they would agree to? Ms.
No,
Howison?
no, because it was charged off. They don't have the ability to do anything because he allowed it to go to collections.
Well,
That was
That's
why I
the
was making a note of that. I know it's past.
so are you talking with the collection agency?
No, I only talked directly with Foundation Finance.
But they've discharged it, correct?
I mean, they
They
still
handed it
are,
off to us,
they're still accepting payments.
but it went to collection.
Yes, it's in collections. It's been in collections since February 28th of 2022.
What can you make in the form of payments?
I'm paying $150 a month already. But that doesn't get it paid off very quickly. I understand that, Your
No.
Honor. I mean, if I can be given a length of time at least to deal with it, I don't know.
How much time are you requesting?
$12,000 is a lot of money.
Oh, I know it is, believe me.
Is there a reasonable standard for this? I don't know.
About 6 months.
Yes.
Any objection to that?
No.
6 months. We'll schedule a date now. If it is paid off and proof is provided, we won't need to have a hearing. If it is not paid off, parties need to appear. We have a date.
New lady in the back,
I'm
so
sorry, I'm
pissed off.
severely enforcing the judgment that's been entered.
I understand, yeah.
Parties need to appear. If it is paid off and proof is, any objection to that?
Watch her freak out.
6 months. We'll schedule a date now. If it is paid off and proof is provided, we won't need to have a hearing. If
That's
it
his
is
new
not paid
wife.
off, parties need to appear. We have a date. Now, I'm sorry, I'm severely enforcing the judgment that's been entered.
I understand, yeah.
And also, I'll say something. My ex-husband finally got his ass in gear to get divorced from me when the bank said to him, "You ain't getting a loan with when you're still married to this other lady." Like the bank is sort of the be all end all. So he had to, as long as once you're divorced, it's fine. But like you don't have to be married. But you can't be married to somebody else and not have them on the title of the loan, I guess, because of the implications of that. So anyways, but yeah, interesting. I'm always amazed at some of these people. I live in this weird world where I pay a lot of money for rent, and I always have. And I actually, in fact, pay a lot more money than a lot of people do for their mortgages. But I've never owned anything. I've always rented, paid other people's mortgages. So it's an interesting like dichotomy. But to see, pretty small loan amounts some of these times, under $100,000 to buy a house is like baffling to me. God, that's not even the down payment for a house where I live.
Your Honor, you want me to file a motion for the home loan as well? Because she hasn't done the home loan out of my name either. Or should I file a motion to come back?
I can't tell you what, you can file whatever motion.
I'll file a
you think are
motion and
appropriate.
we'll take care of that another day.
September 26th.
Can the parties be available September 26th?
Yes.
I realize
Great.
what I should have done is bought a house not where I live and rented it out when I was younger. I didn't. But like literally the houses around here are millions of dollars, even for the shittiest little house. So it's just not feasible. But I should have bought something somewhere else and then just like rented it out and had then something. Hindsight's 20/20, ain't it?
90 minutes. We're going to give you notice now. And hopefully by that time, we can have some, hopefully resolution on that issue. I'm glad that you're both looking at the best interest of the children regarding making these dates consistent with each other, contiguous, I should say, connected. And let's move forward. We'll provide notice. That'll conclude the proceedings and we'll go off. Thank you.
Thank you.
Everybody in this town rents part of their house out, Bill. You have to if you want a mortgage. It's just you have to have 2 or 3 incomes coming into a home, like 2 adult incomes and a rental income to afford $6,000 or $7,000 a month mortgage payments here. It's terrible. It's terrible. It's bad. It's a bad housing market. But I can't fix that problem. What should we do instead? Watch more court? I think so. Why don't we watch another one that I got? And, oh, that's long. Oh, I think it's just long because I forgot to cut it off. Let's just, hold on. If this is actually 50 minutes, then we won't watch it. But if it's actually... Yeah, look, it jumped to Judge Simpson. Perfect. Okay, so we'll just watch the bar until it jumps to Judge Simpson. Adam, I live on Vancouver Island in British Columbia, Canada. Humble brag. Hi, Katie9.
Versus Jeremy Walter, as well as Walter versus Corian. File number 155755DP. You're supposed to receive a companion probate
DP.
file as well. You've not received that. Regarding I would please. This is a motion to modify parenting time at request of a GAL. Mr. Walter is present. He's in pro per. Corians are present. Is your name Patrick?
Good morning, Your Honor. Attorney Patrick Barry, PA.
Barry.
539. Yes.
Okay, thank you. We're going to be grabbing the guardianship file as well.
Understood, Your Honor.
Uh,
Oh my God, when I was a
List
kid
your
and my
mo- your
parents
motion.
first divorced, my dad used to take me and my sister out for breakfast sometimes. You're heading out by me next week, Katie9? That's awesome. Where are you going, Vancouver? Or Washington? But anyways, what I was saying is that when Cellulite Yoga Pants said that, let me get you crayons with your kitty menu. My dad used to take me and my sister out for breakfast, and I think that was my first memory of going out for breakfast. Oh, Bellingham, that is very close. We could take the ferry. That's awesome. Have fun. I think the weather, I don't know what the weather's doing. It's always raining. Sorry. But anyways, and they would put whipped cream and sprinkles on the waffles. Oh, and I don't really like whipped cream. To this day, it's not something I choose to put on anything, but I still remember that so much. Just like whipped cream and sprinkles on waffles. Like, wow. It was insane. And the ladies were always real nice to us. It was such a divorced dad thing to do, though, back then. Nowadays, that's pretty normal, but back then it was like, I don't know. It felt special.
You may proceed.
Thank you, Your Honor. The parties in this
Can you go to the
matter.
podium?
Yes. Your Honor, we're here today on a motion on behalf of my clients. We're here to modify grandparenting time. We're asking for supervised period time for the defendant, and we're requesting a guardian ad litem in this matter. The parties in this matter have one minor child, Madison Chirac, age 9. My clients are grandparents of this child. As it currently stands, the last order was entered in June of 2022 and has attached as Exhibit A. The order is quite long, so I'll just get to
Oh, please then don't read it, bro. Your audio sucks. If you didn't catch that, this is an order asking for grandparenting time to be enforced. And it appears to me the way that they're sounding it is... Katie, now you're making me laugh. The thousands of nitrous cartridges. Do you remember that case that we watched that one time where they presented all the photos of that lady's like absolutely fucking stacks of them? Stacks of those nitrous cartridges. Anyways. Oh, my roommate left. Oh, finally. Okay, we can talk about him. No, I'm just joking. No, but seriously, they're trying to get grandparenting time. I think Michigan is one of the only states that does do grandparenting time. But it sounds to me that they are actually trying to enforce that upon a couple. So the parents that are together that have this child, is that what's happening here? What an interesting case. Can you do that? I thought now wait a second. I thought in America that you get to choose who sees your kid. I didn't think grandparenting time was enforceable. And this is a lawyer, by the way, John. He's talking very fast. I wish I could fix the audio here. If anybody lives in Michigan and wants to go do a good deed, go fix the audio.
The relevant part, which is where we're at now, phase 8. In phase 8, Your Honor, my clients are awarded parenting time or grandparenting time the second weekend of each month from Friday at 6 until Sunday at 6.
Okay, counsel, let me interrupt for a second. Phase 8 is the final phase, correct?
Yes, Your Honor.
Has it been completed?
No, Your Honor, has not.
If it's not been completed, then how is there standing the final motion for grandparenting?
Well, Your Honor, phase 8 was never completed according to the schedule that the defendant was supposed to follow. He was supposed to have primary parenting time, but my clients have had primary parenting time since the order was entered.
Right, well, how does that fly with following case law, Straub versus Straub, Heltzel versus Heltzel, and Eldridge versus Ziny, Z-I-N-Y? There's no order yet.
Well, there is a grandparenting time order, Your Honor, and there's an order for.
There's a grandparenting time relative to the steps, but there's a provision in the order that once the order is perfected, then we can proceed accordingly. But the order has not been perfected yet. No one has filed a motion to perfect the order.
Well, Your Honor, I believe it was the defendant's responsibility to file a motion to perfect the order and ask for sole legal, sole physical custody. That never happened. And under the circumstances we're facing now, with my clients being the primary custodian, it's imperative that we file this motion and the court know what's going on for this child. We're in dire need of a guardian ad litem. We're in dire need of modifying the grandparenting time. Your Honor, could I go through the change of circumstance?
Just a moment. Father does not have legal custody.
He does not.
Under the statute, to ask for grandparenting rights, there has to be a parent that has, the agreed parent has to have legal custody. We don't have that yet.
Okay. But the order executed in 2022, Your Honor, did grant my client's grandparenting time.
Correct. Correct. So this is really a parenting time motion.
Essentially.
At best, but again, the original order has not been perfected.
Right, Your Honor.
So hold on to that thought for just a second. If we're not, are we at we're not at the completion of all the phases then?
We should be, Your Honor, but no, the defendant hasn't completed all of the phases. I mean,
What are you alleging he's not completed yet?
Your Honor, he hasn't exercised his parenting time in accordance with phase 8. I believe I granted him parenting time every weekend, Friday at 6 p.m. until Sunday at 6 p.m. with the midweek overnight. That never happened. And then after 2023, June of 2023, either party made motion in court for perfection of custody of the minor child in the event phase 8 is successfully completed. But it's been 3 years, Your Honor, and no action has been taken. My clients have been the primary custodian.
Right, under the guardianship.
Under the guardianship, yes, Your Honor.
I don't really want to work tonight, you guys. I'd rather just do a long show. Well, we're already doing a long show.
About 5 seconds. Sir.
Yes, sir.
Actually, let me place all of you under oath. All three, raise your right hand.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Name is Jeremy Walter.
Yes, sir.
Mr. Walter, have you completed the steps in the order?
I have every weekend got my daughter from Friday at 6 to Sunday at 6. I haven't exercised the overnight during midweek because I'm currently in college. I have school. I have my other son that lives with me all the time. I'll admit, I thought that we were in agreement though. Honestly, I had no idea that they were planning to even take me to court, Your Honor. I thought we had a good relationship. My mom was at my house February 9th, helping my daughters get ready for the daughter dance. And I sent pictures of her standing next to my daughter's bed. And these things they're saying against me are lies. I've had my daughter every weekend, and the only other thing that I haven't completed, I'm sorry, go ahead.
So if there's a midday overnight, you're stating you've not completed it.
No, and also
Is that correct?
Yes, sir. I have not done that. You're right.
Okay, so we haven't completed the phases yet, it sounds like. Unless there's a stipulation by the parties that they've completed it.
Well, no, Your Honor, there is no stipulation here. I don't think the parties here can come to any sort of agreement. It's just the fact of the matter is, I mean, if this motion has to be refiled as a grandparent time motion on the guardianship matter, we can do that, but Your Honor, this matter was filed in the family division, and the order was entered in the family division, granting my parents this grandparenting time. And again, I mean, they've been the primary custodians of this child. Mr. Walters is testifying that he's exercising parent time Friday through Sunday. That never happened. It's Friday through Saturday and occasional overnights on Sunday, but that was rare, Your Honor.
Okay, why don't you go with your argument, and then if you want to establish testimony or bring forth testimony regarding whether the order has been, previous orders have been complied with, you may do so.
I understand, Your Honor.
Go ahead, sir.
Thank you, Judge. So, Your Honor, since the entry of the last judgment, there's been proper cause or change of circumstances as follows. The child hasn't had a proper bed at defendant's residence since spring of 2024, and essentially has been sleeping in a wooden box on the floor. We have that attached as Exhibit B in my motion, Your Honor. The defendant admitted her mattress was damaged and stated he would only replace it if he received his tax refund. In addition to that, the child is routinely exposed to marijuana use in the defendant's home where he smokes in her presence. The child often returns smelling like marijuana. The smell is in her hair, it's in her clothes, it's in her belongings. The defendant has other children as well. They are in contact with my client and often inform her as to what's going on in his house.
Well, but that's hearsay, though. So you don't-
Yes, Your Honor. Yes, but just stating it until the court is over, and we can have them testify later time until the court orders an evidentiary hearing. Your Honor, based on information and belief, the defendant has a drinking problem on January 10th of 2025. He asked his own 17-year-old son to drink alcohol with him. It's creating an unstable environment for the child, and it's an unsafe environment for the child. He has exhibited severe mental instability characterized by uncontrollable rage, anger, impulsive behavior. It's created a constant state of instability in both his life and the life of the children. The order does state both parties have to complete a psychological examination, Your Honor, but that has not occurred yet. If the court does enter an order today, I would ask that the parties.
It was all parties for a psychological eval.
Yes, Your Honor, that's correct.
No one has completed it?
No, Your Honor, no, that's not completed.
Even your own client?
Yes, Your Honor, they tried to find a provider that would cover them through their insurance, but it's only private, it's quite expensive, but they are willing to comply today and get a psychological evaluation as soon as possible. And Your Honor, the defendant has posted a Facebook video questioning the child about not having a bed and being exposed to marijuana. He posted this video on Facebook. He's touching the child in a very awkward manner, and then putting in the caption on Facebook that this is my client's fault that they're alienating the child. He's failed to comply with the court ordered parent time schedule. He often misses scheduled visits. He hasn't followed the court ordered phases of parenting time and cannot have Madison overnight on Sundays due to his inability to take her to school on time. The defendant has frequently asked my clients for food, both Madison and the defendant's son stated there's not enough food at the house. The defendant does not have safe or legal transportation at his house. At one point, he admitted to my clients that he fled the scene of a car accident. He has job instability. He's had approximately 10 to 12 jobs in the most recent years. And based on information and belief, Your Honor, we believe he was arrested for panhandling, friendly with Michigan. Your Honor, he consistently disparages my client.
This guy, I believe, is being blindsided by this from his parents. This is terrible. This is really sad. They already have custody. Like, why is it a sneak attack like this? This feels yucky. I fucking don't like this.
And uses vulgar language towards them. We have that attached as Exhibit F, and I have some additional supplemental exhibits of Mr. Walters communicating with my clients using some of the nastiest language you've ever seen in regards to parenting time and co-parenting this minor child.
Bitch.
Your Honor, he's threatened that if you were ever to gain full custody of the child, her maternal family would never see her again. This is deeply concerning due to the history of the hostile rage, the verbal abuse, the unstable living environment, all of which demonstrate a lack of adequate care. Your Honor, he's engaged in inappropriate behavior. My understanding is that he asked the minor child, who's 9 years old, to bathe him, raising serious concerns for her well-being.
Whoa. Why didn't you lead with that, bro? Why are you letting her go every weekend then? No. That's absurd. is this actually the lawyer's first day? And no offense, bro, but this is a terrible presentation of this. Absolutely terrible. I've seen pro se litigants with 3 brain cells do better. You understand?
He's never participated in the child's education. He's never attended a parent-teacher conference. He doesn't communicate with her school or her teachers. Really assist with their homework. Again, my clients have had this child Monday through Friday since this order's been entered and up until a few months ago. So they've been doing all of these duties for the child. He's isolated the child from a maternal family and social network by refusing to allow her to attend family functions, birthday parties, and other social events, Your Honor. We're
We
asking the
have
court
her
to
5
be
days a
able
week.
to, requesting an in-camera interview of the minor child, so the court has a better understanding of what's going on with Madison. Your Honor, we're asking for his parent time to be suspended, and for it to be supervised. If the court does not go with this suspension at a third-party facility twice a month at his own expense, until he can demonstrate the following: a proper bed and sleeping arrangements, stable and safe housing, sufficient and nutritious food in a drug-free and alcohol-free environment, along with safe transportation. We're also asking for a guardian ad litem to be appointed to represent Madison's best interests and provide an independent assessment of her needs. Again, Your Honor, we're requesting also an in-camera interview of the minor child. Your Honor, my client also bought the minor child a phone. She pays for the phone bill. He's prohibiting the minor child from texting my client or having any sort of communication with her. And once again, Your Honor, I must stress the fact that I believe the parties should go to this psychological evaluation, have it done, and submit that the findings to the court, so the court can make a decision moving forward as to grandparenting time and Mr. Walter's parenting time. And that's all I have for the court today, Your Honor.
Okay, before I go to Mr. Walter, on page 4 of the order,
Yes.
it says, based on the parties' agreement, after permanent custody is granted to the defendant Jeremy Walter, the court finds that the guardian shall enjoy the following grandparenting time with the minor child until further order of the court. And then obviously it spells out what the grandparenting time is. We're not even there yet.
Well, Your Honor, respectfully, I don't believe Mr. Walters is sufficient to have sole legal and sole fiscal custody. I mean, all of the things that are going on in this motion, along with my numerous exhibits, it doesn't show that he made major life decisions for the child or has the moral fitness to take care of his child. Your Honor, I don't think he'll ever perfect sole legal and sole fiscal custody. I think he'll leave it as it is, leaving my clients in a limbo. Again, my clients have been the primary caretakers, and they're just taking care of their child or their grandchild as best as they can, with really no legal backing
Freudian
behind it at
slip
this point,
there.
because as you're aware, phase 8 hasn't been completed yet, and their grandparents have been eliminated
OMB,
political
we're
order
so
despite
happy
being
for
in Congress.
thee.
But you would agree, though, that the order does spell out phase 8, second paragraph, on or after June 30, 2023. We're almost talking 2 years.
Yes, Judge.
The party, either party may file with the court, may motion the court for the perfection of custody of the minor child. And in the event phase 8 is successfully completed, then and in such event, permanent custody shall be granted to father. So we're not even there yet.
I understand, Judge. I completely understand the court's point, but Your Honor, the plaintiff, Patricia Sherrick, I mean, she's never participated in the case. Mr. Walters, he has not actively done anything in regards to having legal custody, having fiscal custody. It's more of a weekend thing with the child, and that's it. And that's his role as it stands. My clients are really acting as the primary custodians here. Under the grandparenting time statute, I'm not sure if they'd be able to pursue sole legal and sole fiscal custody, perhaps with their guardianship. But Your Honor, with this order that we have here today, I mean, the court has to take action. It has to get involved. It has to intervene with what's going on with Madison, Your Honor. It's very urgent.
Okay, thank you. Mr. Walter, your response. Please stand when you address it.
Yes, sir. First, I want to say my mother and Terry could have called Child Protective Services anytime to have these allegations investigated on Mitch's advice when that, Mitch here, worker here.
You mean Mr. Holden?
Yeah, Mr. Holden,
Oh.
sorry. On Mr. Holden's advice, because I immediately went to him when I got this in the mail. I thought we had a great relationship. This is my mother. And when he says that,
Where?
this is my mother here. And when he says that I'm keeping my daughter from my maternal family, this is also my family. My mother doesn't want me involved in our family. I live with my son all the time. They told me that when Mitch told me to get a hold of Child, yeah, Mr. Holden, I'm sorry.
I mean, I don't I don't call
I
you by your
apologize.
first name.
Okay.
I'm being respectful. That's what I'm
I'm
asking
sorry.
for.
I'm not getting disrespect. I'm getting the fact that he actually is in good contact with the friend of the court, Mitch. Judge, and this is a bashing session. This is inappropriate in my opinion. File the proper motion and follow the proper steps. He raises such a good point. If you are so fucking concerned about the safety of this child, call CPS. Call them. They'll respond. The fact that you filed this motion and then, I mean, it's baffling. It really is.
Mr. Holtwood, on his advice, I got a hold of Child Protective Services. I said, I have food, I have a bed for my daughter. I took pictures, I sent them to Mitch and as well as the circuit court through email. And
Court can't look at them though. Court cannot look at them. If one party sends,
I sent it to his attorney as well.
that's fine. I don't
Oh,
care.
okay.
But you have to understand the rules of evidence. Anyone can send the court whatever they wanted.
Okay,
But it has to be entered through the court as an exhibit.
okay.
So
Well, I didn't
if you wish
understand
to
that.
offer that down the road, that's up to you.
Okay.
That's why.
Well, I do. Mainly what I want to say in his allegations, I thought that we had a good agreement. I know right now my license is suspended. I have had some troubles with work and stuff, and I thought that we had my mom lives less than a block from my house. I thought that Madison, on the weekends, I get my daughter, my son lives with me all the time, and I also get my ex's daughter, Remy, which she doesn't have a dad. And I've been having her, they've been raised as sisters. My mother doesn't want Remy and Madison to be sisters. I guess, because she doesn't want, she's done everything in her power to try to, like last year on Madison's birthday, my daughter Remy didn't even receive an invite, but my son Caden did.
Okay, Mr. Walter, the allegations are that there's questions regarding the child's mattress and sleeping in a wooden box.
Yeah, okay. When they took that picture, I'll tell you what happened with that.
Well,
When
okay, please.
It was a 60-degree weekend, the weekend before. I had Madison's bed out in the shed. I let my girls camp out there, okay? In the shed. Well, the next weekend, I didn't bring it right back in. And my parent, or Terry and Brenda, had told Madison, take a picture that your bed's out in the shed right now and say you don't have a bed. And I literally, they called the police that night. I sent a video to Mr. Holbrook and the court as well. I mean, this was before we even had this court day. I sent this to Mr. Holbrook because he's been the one all along that's overseen my case. And any evidence we have of wrongdoing or anything, I've always contacted Mr. Holbrook. He's always been real and legit with me and always been very respectful. I mean, I like Mr. Holbrook a lot. Anyways, I sent that immediately to him. He said, should we file a motion? I said, well, I have used bad language over app close. I don't want them to file a motion too. I guess we can just let it go to let it go.
Melanie. What happens in the shed stays in the shed. Everybody deserves their own period fence or period room. If you don't know what we're talking about, that's a throwback to another case. We've covered so many cases around here. I'm hazarding a guess that we might have covered 3,000 cases soon. Nuts. Welcome, Melanie.
And I won't go through with this because 2 weeks ago, your court actually had a date set up that we were both gonna have to go to court for our motions that said that, I use bad language on app close. I mean, I guess you would call that abuse of our order, or I don't know what the correct legal term is, but I was gonna have to come to court to say that my parents coached Madison to take a picture of that bed, and I sent.
No, MB, but I'll look right now. Thank you so much for 16 months of support and more. I'll go look right now.
That image that was all set up, and then they were gonna come to court and said I used bad language over app close. I said, I thought we were getting along again. Like I said, my mother was in my home smiling, taking pictures with my daughters. I went to daddy-daughter dance. I thought things were fine, so I didn't want to push that matter. I have enough stuff going on in my life. I'm in college with a 3.9, 8 months away from getting my bachelor's degree in writing for film and television for LA Film School. I didn't have time to put myself into this legal craziness. And I thought that me and my mom could get along. I'll admit, I have not pushed the order. Mitch has told me for a year
Mitch. Mitch has told him for a year. MB, thank you so much. I'm sorry. I don't know why I'm not getting these alerts. I'm not getting these alerts, but I see it now. You are so sweet. Also, Reseller Road Trip Adventures. I gotta get her my address. You guys are so sweet. Thank you so much. And thank you all for the support as always. Seriously. Greetings from Maine. Love that, Melanie. Love that. Is Maine? No, Maine's not an island, right? Forgive my lack of knowledge. I am Canadian, and I'm from the West Coast. The best coast on the West Coast. No, I'm just joking. I love the East Coast too. You're almost missed it a little bit. We have a little bit left, Covey Clown, but not terribly. Not an island. But it has water, right? It's surrounded by water. A lot of water. A coast? At least a coast. Oh, God. Only Hawaii is an island. Huh? What about Alaska? It looks like an island on the map. That's a joke. That's a joke. That's a joke. Also, I actually live on an island. Vancouver Island.
Jeremy, you can perfect the order at any time, but I didn't feel I was quite capable to have Madison all the time. And I thought we had a good enough relationship that I could have my daughter on the weekends. My son lives with me all the time, like I said, and I thought that we could continue the way things were until I was, financially stable enough and to be able to give myself 100% for my daughter. So I was waiting and leaving things as they were. I mean, I'll admit to that 100%. But these crazy allegations are making of no food in my home. Anytime they could have called CPS for 2 years. And another thing too, I never asked my
But
daughter.
you're not denying it. You just.
No, I am denying.
No, you didn't. Not initially. You said they could call CPS at any time.
No, I'm saying, yeah, that means I'm denying. I have food.
No, it
in my
doesn't
home.
mean you're denying it.
Okay, well, that's what I meant to say, sir. That's what I meant to say, sorry.
How do you respond to the marijuana usage?
I do use marijuana, but never in front of my children. Never. Never in the same room as my child, never.
What about the allegation?
I do not drink.
Alcohol.
I do not drink.
What about the allegation? Okay, you don't drink at all.
No.
And you've not completed a psychological evaluation either.
I believe I did, because I did the counseling for an entire year leading up to me getting the order. And then also, my mom, a big part of our order in the phase A, I don't know if you looked at it, but it says that we're supposed to go into family counseling to repair our relationship, which my mom has refused for 2 years.
Your Honor, may I respond to that?
Yes, please.
Thank you, Judge. Your Honor, he sent an email to the court and CC'd my office. He showed a picture of a fridge that was full of food that looked like it was just stuck there last minute. However, if you look at the condition of the fridge, it is simply deplorable. I mean, stains everywhere, food drippings everywhere. I mean, it's just one of the
Hold
worst things
on,
I've ever
sir.
came to showing that or trying to prove.
Hold on. Because we can... Should we? I mean, here's the thing. My fridge has drips in it. My fridge has stains on one part that I can't get off no matter what I use, okay? And there's a difference between just like a fridge that's not pristine, ready for an influencer to come in and do a restock, or like, like a fridge that's stuck shut because it's never open and there's bugs and shit. Like, fuck off. Like, no, that's ridiculous. I could show you my fridge right now, and if somebody was accusing me of not providing food based on the state of my fridge right now, I would fucking lose it. Because we all know I'm a personal chef. I cook to order around here in this house. Cook to order. But I do not clean to order. That's the funny part about that. Difficult. I wish I did. I wish I did. I'm getting better. But cleaning is not the most important part of cooking, although it is very important, and I get that. I did film myself making cookies last night, by the way. Gotta edit that somehow. I was like, oh, this will be a 5-minute video. 30 minutes later. Oh, God. A magic sponge. I have magic erasers. I have scrub daddies. I have scrub mommies. I have all of those things. I have Windex. I have vinegar. I have Pine Sol. I have other cleaners. Some stains are just fucked. I try and rinse out the fridge every once in a while, but that's the way it is. The worst was when there was a spill in the freezer somehow, and then I could see it every time, and then another thing of corn spilled in the freezer. Oh my God, for the longest time, a little piece of corn was like popping out of the freezer every time I opened it, until finally I emptied the entire freezer and I scrubbed it down. It was terrible. It was a terrible job. Yeah, blew up Diet Coke in the freezer. I think that was what it was. It was a Coke. Everything else manages in the freezer pretty good. But anyways, okay, let's finish this off.
Establish the burden of proof that he's able to provide for the child. It was just terrible. Your Honor, he never addressed having a bed for the minor child. I mean, I still to this day, I don't know if he bought a bed for the child. I don't believe he did. He never stated that he did. He never testified that he did. He doesn't have a good relationship with my client, never did, because if you look at Exhibit F, he disparages my
That's
client.
a good idea for the podcast, Covey Clown. Dirty kitchen. I like that. Maybe messy? Oh, I dropped my pen. Oh, maybe messy. But dirty actually is a better double entendre. A can of biscuits explode in the fridge was not good. No, I wouldn't think so. I look like a can of biscuits exploded at the top of my pants. You know, the best, most popular show I ever did was a kitchen show. It was not on this network, let's say.
I brought additional exhibits.
Well, you're familiar with the relationship
Yes,
with these individuals.
And Your Honor, in regards to coaching, there's no coaching going on. If we're asking for a guardian ad litem to represent the child, that's a third party independent.
Who's going to pay for that?
Your Honor, I propose that the parties split the cost for that. And moving on, Your Honor, he admitted he is incapable of having the child full time. And we believe he has mental health issues, he's just not using his meds. Your Honor, I mean, all of that testimony taken into consideration, I think at the minimum, we said guardian ad litem should be appointed in this matter.
What's your response to a guardian ad litem, sir?
First of all, I'm not really understanding what that is.
It's an attorney that represents the child alone.
I believe that I couldn't afford an attorney, obviously. It's crazy that my mom attacked me while I was out of work for a month and a half, and then my mom's like a spider lying in wait to come attack. I'm sorry, I know I shouldn't have said that.
You're getting into the weeds, sir.
Okay, I'm just trying to understand, what does a guardian ad litem exactly do, though?
That is an attorney that represents the minor child and focuses on the child's best interest and needs. And may make a recommendation to the court regarding how the child is to be living or where to be living moving forward. They can make recommendations.
I'm gonna say that I don't agree with that. We have the motion in order for a reason. My mom has made it so I cannot complete this final phase of our thing. And I feel like she doesn't ever want me to have my daughter. I thought that we had a great relationship. I thought we were building rich. We spent Christmas together with our family, with my son. I thought we were building our relationship, and now come to find out that is not the case at all. So I'm gonna say that I disagree with that. I think that I'm gonna have to get an attorney, obviously, because of these allegations they're making and the things they're saying, but at this time, yes, I would deny that on my side.
What the court is going to do at this point, counsel, is we're going to, and you, if you wish to file supplemental pleadings, you may.
Yes, sir.
We don't have a perfect, you may be seated, sir. We don't have anything in the court order or anything that perfects the court order as it pertains to phase A. So as a result, we're still in whatever phase may be going on. If it's phase A, it's a previous phase. So I think the hearing is going to be about whether or not father's completed all the phases to perfect custody. In the event that he has, of course, we'll have the hearing on that. Then at that point in time, we can address grandparent rights.
Yes, sir.
If he is not, then we may have to look at potentially other phases or other remedies that may be available, I don't know. And also too, let's be very honest here. Both parties reside in Genesee County.
Yes, Your Honor, that was one of my next things to go to.
And unless the order is either perfected, because we can't hand off a case, a motion that's pending in this court to Genesee.
Right.
That's the court rule. We can't do that. So the intent of the court was, to be very honest, if there was a perfection and we get it perfected, and you want to file a motion, maybe there's a stipulation or something that could be handed over to Genesee. That doesn't mean I don't want the case. That's not the point here. But you're coming in from where?
Well, where's
Where's your office, sir?
Oakland County, Birmingham, Michigan.
Right. I'm thinking Saginaw Street, north end of Flint is a heck of a lot better than West or East Huron Avenue in Badass, right?
It was a nice drive up here, Your Honor.
Well, you'll say that, hopefully you won't say that hopefully you'll say that during beat season, but that's another story. But sir, you're from Genesee County as well, and I'm assuming you'd rather have this matter heard in Genesee if we're able to do so.
Yes, sir.
And I'm not going to speak on behalf of your clients, but I'm thinking they're probably thinking the same.
Yes.
So, but we can't do that yet. So we are going to schedule this for a hearing to determine whether or not the order's been perfected, the motion regarding GAL, all the other motions are preserved, and Ms. Hatch will schedule a special day for that, and it's going to take some time. How soon would you be ready for a hearing?
Your Honor, possibly mid-May, early May.
May 13th.
Check the calendar.
Does that work for you, sir?
Yes, sir.
And then that'll give you time if you wish to see counsel, if you wish to do so.
Yeah, I'm back to work now also too. I actually couldn't get my paycheck early. I was gonna try to bring some child support because I haven't paid child support in a couple of weeks either. I need to get on that, so.
Okay.
Your Honor, was it May 13th for that venture?
Yes, 9 a.m.
Yes.
9 a.m. Also, this is to Mr. Walter. Mr. Walter, the court does not appreciate when you call the county clerk's office and when you're trying to get either videos or pictures to the court, you basically tell them they don't know how to do their job. That's not appropriate. They know how to do their job. You don't know, as it pertains to how matters come before the court, how evidence comes before the court. This individual does because he's a licensed attorney and you're not, and that's no disrespect. Hence, number one, it's probably a good idea for you to seek counsel. Number two, being a little more respectful will go a long way because the clerk's office is an extension of this court. And that's why you don't hear me calling you by your first name. You don't hear me saying anything disparaging because I'm being respectful. And I'd ask you to do the same.
Yes.
It has nothing to do with the merits of this case, but it has a lot to do with how you treat other people. We'll see you next.
Thank you, Judge. Have a wonderful day.
Thank you. That'll be all. We're going to give you notice right now.
And then I have to admit, I was sleeping, so it popped over to Judge Simpson. But that was pretty intense, wasn't it? There will not be another show today. Unfortunately, I do have to work. My hours at work got really cut at my other job. For not my own fault, let's put it that way. Nobody's fault at this level. So that's good news for us because what that means is I will have more time to do YouTube in the next few weeks and more time to hang out with you guys. So in reality, better for us overall, but I will have to start actually making videos. So you guys gotta promise me that you'll watch them, will you? I even dusted off my notebook and have been taking notes on the hearings that I'm watching. So we will be back at posting videos again soon. It's hard. Keep the tips coming if you've got them. I appreciate it. I love new courts. I love you guys too. Thank you again for the gifts. Thank you for the love. Thank you for the hangout. I love it. Made my day so much better. Tomorrow is gonna be Well, it will depend. I heard there's a special thing happening tomorrow, and I don't know when it is on Credence and Mikey. So what I think is that we will probably be in the afternoon or the morning, but keep an eye out. It'll also depend on how work goes tonight. So wish me luck with that. It'll be fine. 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 Anyways, do me a favor. Remember that I love you. And I'm proud of you. And oh, by the way, that judge had more cases that day that we'll watch tomorrow. Crazy ones. Anyways, reminder, I love you, I'm proud of you, and I'll see you in the next video. Okay, bye.
Ways down and ready to